to the support staff, the head of the task team, His Excellency Abbas Damseleku, the Honorable Deputy Minister, Honorable Mukongi. I can see he's not here, but in the confirmation from the minister is that he would be representing the executive in this meeting. Let me also send our regards to Memafu and the team from the DMV. All of you are welcome this morning to this meeting of the Portfolio Committee. It's a virtual meeting in line with our agreement. I also would like to send our greetings to the whip, Ndademinyai. All of you are welcome to the meeting. Can we show, here's the agenda before all of us. The first item would be opening and welcome. The second one would be apologies. The third item will be adoption of the agenda. The fourth item is the consideration. This is the slight change that we have effected because there's an apology from Dr. van Rensburg. In terms of family commitments, he would like to be released at 12 o'clock. I've agreed with him that we'll start with his item so that we allow him to go and do his family commitments. Then we'll have DMV progress reports on the implementation of the plan to ensure compliance with the Gauteng High Court judgment. Then we'll have the briefing by the DMV on Q1 expenditure and performance. Then will be a consideration and adoption of our previous minutes. Can we then move to apology secretariat before we get to the adoption of the agenda?
Thank you, Chair. We've received an apology from the Honorable Minister Angie Motshekga, who is attending the SCOA meeting. We've also received 3 apologies from the members of the committee, Honorable Tebekulu, Honorable Kubukeli, as well as Honorable Ngobeni. I thank you, Chair.
Thank you very much. I would request that we move to the adoption of the agenda. Can we get a mover and a seconder? Honorable Nyaos?
Yes, thank you, Chair. I did raise my hand.
Okay.
I propose that we adopt the agenda, and may I also present my own apology that unfortunately by 12:30 I will have to leave this meeting for other commitments. But until 12:30 I will be fully present and involved in this meeting. Thank you, Chair. I propose adoption of the agenda.
Thank you very much, Honorable Munyai.
I second, please. Thank you very much.
Thank you very much, Honorable Munyai. We can then move to the first item. Dr. Willemse.
Good.
Janse van Rensburg.
There we go, Chair. Yes. Chair, can you see the screen on your side?
Yes, I can see the screen.
All right. Thank you, Chair. And good morning to you, Chair, and to all members present. Thank you for accommodating me in presenting this term program quickly. Members did receive the term program, so this is just formalizing it and going through to see if members agree to the adoption of the proposed program. We have today's, on the 5th of August, we've got today's agenda item, which, as members will recall, stem from the committee's focus in the previous term on making sure that the department complies with this Gauteng High Court judgment. In addition to that, we also have the quarterly tracking of expenditure. So we added the Military Veterans Department's performance report for the first quarter here. What we propose then going forward is on the 12th of August, feedback from the Interdepartmental Working Group on the encroachment of human settlements on military facilities. So members will recall that in the previous year, this matter was raised by members as a serious matter that required collaborative work between a number of departments to address. I think members specifically raised this topic after visits to military facilities around the country where this is very apparent. So this topic was then raised last year, and the departments were requested to put together this interdepartmental working group on this matter. And the matter has stood over a couple of times, so it's finally on the agenda to get feedback in this regard. So a long outstanding matter for the committee. On the 19th of August, we then propose a briefing by the Secretary on Defence and the Chief of the SANDF on progress made in relation to administration of consequence management in the SANDF and the status of boards of inquiry on irregular expenditure and fruitless and wasteful expenditure. So this was last presented about just over a year ago in February 2025. So we've come to a point where there's a need to assess progress in this regard. And Chair, you also raised this matter. This will be a prelude to a potential meeting that we can propose for the next term, where we look at further feedback from the law enforcement agencies, the Hawks and SAPS, on investigation of cases referred to them. But this is a natural first step to see how after a year, if there's any progress within the department in terms of consequence management. And then lastly, we propose on the 26th of August, briefing by National Treasury on the funding of authorized military deployments, and for them to provide a general historic overview, the Treasury and DoD processes, and specifically details on the funding of Operation Prosper, which has become quite contentious. And then in addition to that, since the Department of Defense will be there, also briefing on their first quarter performance, as well as feedback on the 2026 budget report. There were a number of recommendations from the committee that was set for responses by the end of July. So we can use this opportunity as well. We should still receive these recommendations or responses from the department in writing, but perhaps an opportunity for the members then to engage with the matter. Chair, members, the only addition to or only small change that we have proposed to the proposed draft program that members received is this on the last meeting. Given the matter that this deals with military deployments and the Joint Standing Committee of Defense often looks at military deployments or is actually required to report to Parliament on military deployments, with the agreement of the Chair, we propose that this meeting on the 26th of August be done jointly with the Joint Standing Committee of Defense. And Chair, members, that is it. There's only scope for 4 meetings within the parliamentary term. It's quite a short term, but we try to maximize it here. And we really try to look back at what the committee has been doing over the past year and where there's an urgent need for feedback and progress measuring. So this will take us then into the next term, hopefully, where we'll be focusing on the BRRR process. Chair, members, that's it. I also highlighted here whether a meeting is virtual or physical, so members can elaborate on that as well. There's proposed today's virtual meeting, next week also virtual, then the 19th of August physical, and the last one on the 26th would be also virtual. For members that are part of the Joint Standing Committee of Defense as well, just a reminder that on the in this week there's a physical meeting on the 14th of the Joint Standing Committee of Defense, and on the 28th of August there's also a physical meeting of the Joint Standing Committee of Defense. Chair, I'll hand back to you if there's any input on the program. Yeah, thank you for the time. I appreciate it.
Thank you very much, honorable members. I will hand over to you for your submission, Honorable Niels.
Thank you, Chair. I would like to propose adoption of this particular program for the term that we are entering into. And I'm especially happy that we're having the joint session with National Treasury. It was indeed very unfortunate that National Treasury was not available for the emergency earlier meeting that was initiated by the Joint Standing Committee on Defense. So this meeting is absolutely critical. I would have liked to have seen it earlier, But since this seems to be the first time that it can happen, I want to applaud the inclusion of this particular meeting on the 26th of August. Thank you, Chair. I'm proposing adoption of this program.
Okay. Before adoption, Honorable Niehaus, I would like to come in on the same meeting of the 26th of August. Dr. Vele, Janse van Rensburg, request that we do this meeting physical. I would also like to propose an addition that we call in Honorable Musi Maimane and his committee appropriations. Because we need them, both of them, treasury and appropriations, because we're going to discuss rents and cents, and I would not be comfortable security-wise that even enemies of our country will be seeing us talking about rents and cents and fund allocation to the South African National Defence Force. So we may not restrict it, but if it can be physical, so that we can get to engage Treasury, including appropriation if it's possible. If it's not possible, we will then proceed virtual, because anyhow, all the meetings are going to be through a public streaming. But I would have preferred that we have it physical, but it's up to members to decide. Let me give over to Honorable Ate.
Chair, I strongly support your proposal, and with that amendment, then I propose that we accept it.
Okay, thank you.
And Chair, I will second that proposal by the Honourable Hutton then, with the amendments that you've made, which I also strongly support. Thank you.
Thank you very much. Dr. Janse van Rensburg, thank you very much for the program. We hope to work, activate the Joint Standing Committee for the meeting of the 26th. If from your side, as the experts can do as an analysis of the history, yourself and Dr. Steenkamp, the history of the funding of the National Defence Force, I would like it to be covered just in a point form from the Union of South Africa up to date, because I just want to show Treasury how immediately after the 1976 uprising, the general sales tax was increased from 14% to 28%, and the whole allocation was done to strengthen the National Defence Force as part of securing the borders, and how some of the challenges we have today needs us to think in that way, even though we don't increase the tax, but we have to do something considerable that can ensure that we protect the territory and the integrity of the country, because Treasury seem not to understand the role of the National Defence Force in terms of funds allocations and budgets. And they think that just by Holy Spirit or by Holy Cross, the country will be safe without funding allocation to national defense and national security. So I think if we can just do that analysis and forward it to members so that we can arm ourselves for that meeting of the 26th with National Treasury, and it will be a bonus if we can also get appropriations to be there, so that we educate Mr. Musi Maimane as well as Mr. Somadoda Zibi to understand why we need to increase the funding allocation for the National Defence Force. Thank you very much, Dr. Janse van Rensburg. We can then move to the next agenda item. I will hand over to the Deputy Minister of Defence or anybody who's leading the delegation from the Department of Military Veterans. Is there Honorable Mkongi?
I'm good, thank you, Chairperson.
All right.
Yeah, just to first say that we appreciate the call by the portfolio committee that we come before you and account on our activities. Today we are here to brief the portfolio committee on the implementation of the court order. That is the main issue that we previously engaged on. We were just here before you to update you on the finalization of the existing applications for inclusion in the database, finalization of the healthcare benefit and other applications, and also about the appeals board. Our ambassador will do the presentation, Comrade Chairperson. Thank you. Not to waste time for the committee, Chair.
Thank you very much, Honorable Deputy Minister. I'm Honorable Chairperson. I would not want to appear before the Ethics Committee because I'm only limited in a parliamentary process and platform to be referred to as Honorable and referred to others as Honorable too. So I'm afraid if you call me Comrade here, we may think that we are in a BGM of our party. No problem, Honorable DM, it's okay. I pardon you. We can move on. Your Excellency, over to you.
Thank you, Chairperson and honorable members. Thank you very much.
No,
I apologize.
No, you're welcome, Honorable DM. Secretariat, can we flag the presentation? Can we share it? Over to you, Your Excellency.
Thank you, Honorable Chair, and greetings to the Deputy Minister and honorable members, and also members of the delegation. As the Deputy Minister has introduced, this is actually a follow-up to the discussions that were held by the Portfolio Committee previously on the matter of the court case. I have asked our CFO to flight the presentation, and I hope he's going to do that soon, Chair. The focus, as the Deputy Minister has said, is on how we're planning to finalize all currently existing applications for inclusion in the database. Also to deal with the healthcare benefits as well as all the other benefits as directed by the Portfolio Committee before, and then also deal with the reconstitution and finalization of the appeals board. Chair, I note that the presentation by our CFO, who may be out, perhaps, I don't know, I'm not sure what's happening. But Chair, while there it comes, and I hope can we all see the presentation? I think it's rated now.
Yes, we can
Thank
see
you. Thank you. If we go to the next slide, Chairperson, we just contextualizing and recalling that the Gauteng High Court issued an order on the 11th of May. Can we move one slide, CFO, to the next slide? The order was actually issued on the 11th of May, and we have discussed this previously. And we just want, first of all, to note certain matters that emerged from the discussions with the Portfolio Committee previously. One of which was, of course, noting that the matter was not opposed by the department as such, and I think members raised serious concerns about that matter. Just to underline that, the papers were not actually served to the department. Indeed, they were served as we have investigated. But like most of the matters that we have a challenge with in the department, they are served to the state attorney, and then they end up not reaching the relevant people. So this one has become one of those matters where we have been found wanting because the matter was never referred beyond the state attorneys. Also, there was a very big concern from the members when we reported that subsequent to the court order, we met with CMVO just to underline that this meeting was actually at the request of the CMVO itself, because they had asked us to discuss with them how they can assist with regard to the implementation of the court order, because they have some capabilities and capacities that they would like to offer. And in fact, these discussions have been going on because they have offered very, very positive assistance with regard to how we approach these matters, but also looking at other matters that would also fall within this context. Can we move to the next slide then? It looks like the slides are not moving. I'm not sure, CFO, whether there's a challenge, but they seem not to be moving. While we try to actually get to them, I'm aware that the members will recall that the first order is in relation to ensuring that all who qualify for registration under the definition who apply, therefore, to be included in the database must be dealt with and finalized within 90 days. Of course, this was a matter again discussed in detail at the last meeting. Of course, given the issues of the legal interpretation. However, as per the instruction of the committee, therefore the DMV decided with ourselves to deal with all the issues as raised by the portfolio committee, regardless of whether in terms of the interpretation, whatever the legal outcome of the interpretation would be. And therefore this presentation covers those broadly as was instructed by the portfolio committee. Can you move on to the next slide? Now, with regard to the applications for the database, in other words, for people to be included in the database, Chair, there are two processes that have been going on parallel to one another. The first one is through the data verification, enhancement, and cleansing work stream of the PTT, which is led by General Mashwala, and the second one is the processing of such applications in the DMV itself. Now, with regard to the first one, that verification process relates mainly to the non-statutory forces. And as I've said, it has been conducted over the years by General Mashwala's leadership. That process is currently in the last province, which is the Western Cape, and it will conclude its work, Chair, within the time frame that is given. So in other words, all the non-statutory applicants that have applied and are now being verified, that will be concluded by September, certainly by the deadline date of September the 17th. They are currently doing the last province, which is the Western Cape, after the last time we reported they were in KwaZulu-Natal. Now, beyond that point, if there are any other applications that actually come in after that process, they will then be attended to in the normal processes, but within the 90 days of receipt of application. So in that regard, with regard to the non-statutory forces, we will be within the directive of the court. But of course, there are still very serious outstanding issues in that regard, because one of the instructions from the PTT for General Mashwala was to say that for those that apply and can be classified as SDUs or internally trained, etc., they should keep a record of those, and the discussion will be handled later. So that matter will still be pending until the PTT actually handles it. Next slide, please. On the issue of the ones that are being processed within the DMV itself, at the time of our assessment, we were looking at 8,000 plus applicants that were awaiting decision in terms of inclusion in the database. And that number was growing very fast because within a week, each week, the DMV was receiving applications to the tune of about almost 300 a week. Now, to deal with that backlog, we thought requires innovation because it would be very difficult to ensure that we have enough capacity to finalize it within 90 days as per instruction of the court. So we had to actually look at what options we have, bearing in mind that this particular application is actually the gateway or the basis for the possibility to apply for other benefits in the department. You first have to be on the database according to the process currently. So we had to invoke a new plan which actually suggests that we would involve a deeming a clause where all military veterans with force numbers and CPR numbers would be deemed to be already in the database and therefore would be allowed to then apply for other benefits. Next slide, please. Now, this particular initiative, which is the new initiative to ensure that we meet the deadline of the court, an announcement will then be made during the first week of September that all people who have applied before, and the majority of them are actually people with force numbers and CPR numbers. So all those who have applied before, among the 8,000, who have force numbers and CPR numbers, would then be automatically declared to then be deemed to be on the database of the DMV, and therefore would now be eligible to apply for benefits if they so wish, as long as they have those force numbers and CPR numbers. Of course, bearing in mind that not all people with force numbers are actually military veterans, because force numbers are also given to the civilian elements of the defense. Work has already started to reconcile the database of the DMV and the DOD to create a seamless transition between the two, but also to ensure that the ultimate referencing between the two databases in order to establish some of the other criteria for qualifying for specific benefits would actually be also seamless. And as I said, discussions with the CMVO also have been ongoing because they also have been doing work to research the archives and also look at other aspects of this work in order for us to share information on the databases. So those are ongoing. But the implications of that announcement mean that we are going to lose the capacity to actually get information updated before people apply for benefits. So that would require that we actually do the updates. But the implication, therefore, is that there will be no new applications for including in the database from people who have force numbers and CPR numbers, except from members who may not have those, and therefore they can still apply, maybe because they don't they joined the military in a different way, which would be very difficult to understand because they should be having some force numbers. Nevertheless, the application will still be opened and dealt with within the 90 days. So, Chair, in the next slide, we just say the implications are for that we update the application forms so that we can also use the application for benefits to update information with regard to other issues, dependence, current marital status, sometimes ID numbers, because as we have been alerted to, people have different ID numbers from different stages of our ID system in Home Affairs since the 1910s or 1960s. But of course, digitization, Chair, will enhance the process in the future in that we are envisaging that people can be able to update this information digitally. So in other words, they would have a function that would say, are you applying for this benefit? Click here. Are you just updating information? Click here, etc., etc. And therefore, it will become something seamless. We are working on this matter, although we've got our own frustrations with regard to the SITA, but that may be a subject of another day. So next slide, Chair, just in summary, therefore, with regard to Order 1, we are confident that we are within the time frame of the court, and we will have allowed quite a big number of people to be able to then enable to apply for benefits. Now, the second matter, Chair, relates to the benefits themselves. And in terms of the court order, it referred mainly to the healthcare benefit. But again, as part of the discussion, that cannot be separated from the applications that relate to other benefits, backlogs, etc., etc. So there are two aspects to this particular order. If I can deal with the second one, of course, the first thing we want to say is that with regard to this order, the regulations which is referred to here refers to all benefits, not just healthcare, and it directs the DMV to notify applicants of the outcome of their applications within 30 days. And then the second part of the order says they should be referred to the appeals board if they are rejected within 90 days, 90 working days. Now, it's important for us to say that in relation to the referral to the appeals board, that is actually the responsibility of the applicant should they feel the need to do so. Therefore, the DMV cannot actually plan to refer officially, formally, any specific application within 90 days. That would be dependent on the applicant. What the DMV will do is from time to time to update within a period of 90 days of rejection, to update the appeals board of the potential of the people who have been rejected as potential appellants to the board, just so that the board would be aware of what it is faced with in terms of the possibility of the future, without necessarily saying we are formally asking the board to look into those, because that by law is supposed to be taken by the individuals themselves. So written rejections will then be communicated, as the law says, accompanied by advice on how to appeal, including the time frames for lodging such an appeal. So that would be meeting the second part of that directive. The next slide. But on the first part and on the other benefits, it's important for us to first just create a context for this matter in terms of how we would be responding to it, so that members are very much aware of what we are facing here. Starting with healthcare, healthcare provision currently is primarily through the South African Military Health Services, and this is based on an MOU signed with the Department of Military Veterans in 2025. Now, military veterans generally, and understandably so, prefer facilities, SAMS facilities, and SAMS partners in private facilities, rather than public hospitals for various reasons. The number of military veterans authorized to access services increased from 7,000 or so in 2014 to 18,000 to date. And we envisage that the increase is also going to be very exponential in the next phase. And so what happens as a result is that the department ends up owing sums, large sums of money, because SAMS simply accepts whoever comes to them as a military veteran, and they refer them to private hospitals or to SAMS treatment, and then bill the department in that sense. So it's very, very difficult to manage the costs of healthcare with regard to that. Currently, SAMS is owed more than 200 million. And of course, the Secretary of Defense, who is the accounting officer, has recently engaged the department, the DG, as another accounting officer on how to deal with this debt, because, of course, in terms of the law, he is supposed to be taking steps to actually recover the debt owed. Let's go to the next slide. Just to say that one of the challenges that we face with regard to this model is that SAMS has limited footprints, and therefore referral to private healthcare is actually the norm rather than the exception. And it also includes transport costs to infirm military veterans who can't travel on their own, etc. And also the current service is not provided within a managed healthcare service. By that, honorable members, we mean that if you look at medical aids in general, you will find that all of them have managed healthcare, so that each person, each case is managed in a particular way. You know how many, you know what you have access to and for how long, how many times, and you also know when your benefits are actually finished for the year. So in other words, even in the contributory environment where members contribute, they also have their own healthcare provision managed by a managed healthcare provider. Now, with regard to this one, which in fact is not a contributory system, you have unmanaged healthcare, which means people can access the services as much as they want for as long as they want, which is not very easy to manage the costs associated, and therefore budget management. It is very risky. Can we move to the next slide? I'm gonna skip this slide because it's just attempting to look at what the current cost is vis-a-vis the low-cost services of other medical aids. Now, if you look at the cost of healthcare from 2003, 2004 to 2005, 2026, the average of access to healthcare was 40% of the authorized military veterans at the cost of 660 million or so, against a budget allocation which was already a deficit of 438 million, creating a shortfall as given there in terms of the figures. Now, if you use the figure that we are using, which is actually not the realistic cost, but just by dividing the 40% currently, you will find that the cost will far surpass the budget allocation over the years, even the current budget allocations. For example, for the current financial year, for the 2026-27 financial year, we opened with accruals of 280 million against the current allocation of 176 million, indicating a shortfall already of 104 million, excluding the claims for the current financial year, which are still coming as such. So both accounting officers of the DMV and SAMS are under caution already from finance not to continue violating the PFMA as described, which we will get into just now. If we go to pensions, just to also indicate what is happening also at that level in terms of backlogs. We have amended the military veterans pension to try and manage the pensions by ensuring that a clear means test is introduced. But despite that, we still have a challenge there because of the higher than expected demand, of course. The department, for example, in the last financial year, avoided, had to actually get an unauthorized expenditure by exceeding the 8% threshold for 2 consecutive years in terms of environment. So, for example, by not paying 2,143 approved applications where the accumulated liability now is, if I may give a specific figure, it's 260 million as at 30th of June 2026. Now, what that means is that we have got, with regard to those that are already approved, we have had, and the department has had to actually do environment and has moved up to the threshold of 8% in order to ensure that the full year payments are actually made. Then, secondly, currently we have 2,143 approved applications that are not paid yet, and that debt or liability is currently 260 million and growing. And of course, this has already been flagged by the Auditor General as it affects the ability of the DMV to actually continue to be a going concern. The department is working with both JIPA and the National Treasury to begin to cost the pensions with the application of the new regulations in order to determine the total funding requirement. Next slide. So in a sense, if we summarize what I'm saying about pensions, we currently, up to now, we have had 27,100 applicants. That's up to the point at which we were actually dealing with this data, because people are still applying. Now, total applications within that 13,000 that have been finalized are almost 48-50%, 13,000 or so. And of those, the approved ones, which means the ones that are sitting as approved already and are supposed to be paid, there are 6,532. Now, of those, we are already paying 4,330. And within that 4,330, we are currently able to pay with a deficit of that 2 months that I've referred to, which has been supplemented in the last financial year through environment or movement of funds. But of those 2,143, as I've said, have not been paid, and they have been approved since 2023 for that matter, and therefore the accrual of liability I've indicated is currently sitting at about 260 million as we speak, as of June. If we take the next slide, I will skip the slide because it's already repeating what I am saying, except to indicate that we have a shortfall of about 84 million for this. The next slide also captures the ones that I've just talked about that have been approved but are actually not paid, and I've referred to the accumulation, and I just want to then amend the figure that is given as 31 March to move to the 30th of June, that the accumulation by 30 June is 260 million already as at 30 June. So the figure you have there was given as at 30 March. Now we've updated it to 30 June. And of course, we have tried certain means to deal with this. And even though we are working on it, it's not necessarily going to move much. The slide that you are seeing now begins to actually expand on what we are doing with the others. The 13,000 that are remaining. In fact, it was 18,000, and so 5,051 applicants who were public service employed and contributing to the GEPF have already been rejected based on the new regulations, which would not have happened if we hadn't really updated the regulations to introduce the means test. So we have 13,000 which are currently undergoing employment and income verification through SARS, so that we can ensure that they fall within the means. Of course, once the report is received from SARS, then those that are not compliant will then be rejected. But the final, all applications will then be finally actually subjected to the means test. But they also need to update the information. The last bullet point is very critical. JIPA, also in terms of their own legislation, but also in terms of the PFMA on our side, will not make any determination on those who qualify. In other words, they will not finalize the approval until such time the budget challenge matter is resolved by the DMV, because of course the DMV is the client department. If we go to the next slide, the same story we will say about housing and education. In housing, in education, applications for education support have not opened for quite a few years now because of budgetary constraints. So even though people may have wanted to apply, but they can't because that is closed because there's no finance for it. Housing delivery is not moving fast enough to meet the demand, again, because of budgetary constraints. Although the TMTT is now trying to work on a proposal to fast track this. The reason being, if we go to the next slide, we'll just indicate why. The current status of the program in housing, you've got approved numbers who are waiting to be housed. That's about 3,200. And for various reasons, this figure is moving very slowly, regardless of those that more applications. For example, the housing opportunities that are planned for delivery in 2026 are 713. Those are already approved in provincial business plans to be delivered through the budget allocations of the provinces. Now, if you look at that figure and you say per annum, let's actually deliver 700 or so housing, and the housing backlog is huge. Therefore, it would take years to actually meet this. And the TMTT is suggesting that perhaps we should package this as a national program rather than dependent on the provincial budgets, maybe ring-fenced budget, and we're able to then say per annum in the control of the DMV, so many houses can be delivered and there's funding for it, and we can say it can be, the backlog can be dealt with within the number of years. So, Chair, with regard to this order, the Portfolio Committee should know that any approval to spend funds is subject to the availability of the funds in the budget which is approved by Parliament. Section 38, 1 and 2, and Section 39 are very clear in terms of the PFMA in directing what accounting officers can or cannot do with regard to committing the state. Particularly, Section 38(2) says an accounting officer may not commit the department to any liability for which money has not been appropriated, which means in the next slide, if we move to the next slide, we want to emphasize that the backlogs in these benefits, unlike the backlog in the registration process, are not a function of administrative delays, but are a function of lack of resources because the budget does not match. In fact, it's a deficit budget with liabilities that are actually growing. Engagements with Treasury has suggested so far that in the near future, there will be no funds available for dealing with all these benefits as have been outlined. This means that as a result, the Treasury has come up with some measures, remedial measures to actually balance the existing budgets, which themselves are going to create more problems for the DMV, but they are still under discussion. But once they are actually issued as directives, the PFMA says the accounting officer is obliged to implement measures, remedial action that is actually directed by Treasury, including ensuring that these variaments that have been done for the pensions are then locked up as part of the budget of pensions, which means creating a deficit from where these variaments were taken. But that's under discussion at the moment. Therefore, the accounting officer and the minister are faced with two conflicting legal imperatives. One, the court order suggests that all applications must be finalized within 90 days of application. Now, from what I've indicated, the PFMA would say to the accounting officer, you cannot make that decision committing the government to unfunded mandates. Otherwise, you are in violation of the PFMA. So, given that there is a kind of, the budget is creating a moratorium on finalizing any of those from housing, from health, from education within the 90 days as given by the court, we then are proposing the solution which we have consulted on with some legal advice here and there, and including, of course, discussions with the CMVO, that we actually work on the applications up to a point where the preliminary, call it preliminary exclusions are dealt with. But when we reach the points of finalizing, we actually stop at that point until, of course, the funding is going to be available. Therefore, the proposal is that the court is approached to report compliance in terms of what I've actually outlined, but also to report that the compliance with regard to the benefits part would go up to the point of clearing whatever issues can be cleared, but cannot be finalized because the law doesn't allow for that kind of finalization. In the meantime, with regard to healthcare, discussions would actually take place, and they've started already, with the Ministry of Health to make special arrangements for the military veterans to access certain hospitals and to fast track that access and ensure that they don't have problems. While, as I said, because the preference is mainly SAMS, and we agree with that, while the reinvigoration of SAMS is actually taking place, including the reconstruction of one military hospital, and the Ministry of Health is also looking at ensuring that it allows for more specialists to be available for purposes of SAMS, and even using SAMS as one of the NHI pilots. So that conversation will continue. And in the meantime, the health regulations would be amended to introduce elements of the managed healthcare, because even when that is done, you still need to introduce the managed healthcare. So that's the only way we can actually meet the deadlines with regard to benefits. Otherwise, the accounting officers and therefore the executive authority would be liable to be charged for violating the PFMA. The next one, which is quicker, is the order number 3. Now, this one has to do with the reconstruction of the appeal board. The members would recall that the issue here has to do with whether it was properly constituted. And indeed, the investigation suggests that the process of appointing the board did not follow all the processes that are prescribed by law. The main one being consultation with the association, in this case, SAMVA. The reality is that the law, unfortunately, or perhaps for whatever reason, was important when the law was actually made, suggests that the minister must reach agreement, because it says in consultation with. So it means the minister must reach agreement with the SANVA. It's a kind of negotiation until you reach an agreement. It's not just consultation for purposes of input. Then the appointment can be made. That's what the law says. So in other words, the current appeals board was not reached in agreement in consultation with SANVA. So it actually makes it unlawfully appointed. And as a result, the minister has requested the board to suspend its activities for now, pending that consultation and the determination of whether SANVA can actually confirm that that board would then be legalized, or perhaps there are additions or subtractions until a kind of agreement is reached. So currently, what we are doing is we are in the process of in the next slide of trying to deal with correcting this particular issue. Nevertheless, members will also be aware, because it has also emerged from questions from some of the members in Parliament, that there are challenges with regard to SANVA itself and its conference and the election of the new leadership. Those challenges are based on the letters that the minister has received from individuals, from CMVO, as well as the questions that I've referred to from members of Parliament who want to know whether the conference itself went according to the Constitution and the leadership is properly constituted. So that challenge means that we have to actually deal with that question at the same time to assure the minister, to assure herself that the SANVA I'm consulting is not going to be challenged within the next month or so, and then suddenly all their decisions are null and void, which will then impact on, again, whether there was a proper consultation with SANVA. So currently, we are trying to navigate that kind of legality, which also involves getting from SANVA themselves a report on the conference, on the processes, which they have just submitted, as they were given a deadline of the 27th of the month, and then looking at what the legalities are as to whether we can actually continue consulting them and upholding whatever decisions, if at all, at the end of the day, there's a legal challenge by any one of the actors that have alluded to who are challenging the constitutionality of the SANVA conference. So that we hopefully going to be able to finalize that within the 90 days period. In other words, to get the board back to action by the beginning of September as such, pending, of course, the process of legality of that consultation. So, Chair, in summary, Court Order 1 and 3 seem to be possible to be met within the 90 days that has been directed by the court, save only the issues I've just raised with regard to consultation with SAMVA. But Order 2 is challenging due to lack of funds and the legal obligations of the accounting officer not to make decisions that will commit the state to any liability without any budget. And therefore, it requires partial implementation in that you can continue to actually have these. But also, it requires that we go and communicate with the court to explain this. Of course, there's precedence in the courts with regard to committing the state. And of course, we continue to discuss with the health department to ensure that at least decisions can still be made which are not committing the state to any budgetary constraints, because you'll be using the public hospitals as such and access, so that people who still need healthcare in an emergency basis can be able to actually access healthcare. However, there are larger issues of policy that are being raised and discussed by Treasury and others, which would say that how do we then deal with this matter in the long term so that we do not have the fiscal risks that seem to accompany it, both from the point of view of the numbers that are unending and growing, and also from the point of view of the capacity of the state to be able to meet these obligations. Chair, that's the brief today, and thank you very much for the opportunity. I submit.
Thank you very much, Your Excellency. Based on the number of apologies of 12 o'clock and 12:30, I would request that we go straight to the discussion on this matter before we move to the next point. Can we get the hands from members? There's a hand of Honorable Niels. Over to you, Honorable Aten, Honorable Kele, in that order.
Thank you, Honorable Chair. And let me also thank the Ambassador for the presentation that he had given us. Chair, of course, military veterans have been subjected to years of unreasonable administrative delay in what is really the very gateway process for them to be able to access any of their rights, and that is registration on the National Military Veterans Database. The core issue that we are faced with, and I'm not sure it was addressed in this presentation, is the balance between protecting the integrity of that database through proper verification and at the same time ensuring that verification does not become a permanent barrier. The Parliamentary Research Unit in their research has correctly identified this as the critical tension. The lived experience of veterans had been catastrophic. I'm not going to go into all the details, but we all know that applications dating back to 2014 continue to remain unresolved. The database enhancement and cleansing workstream, led by Major General retired Mushwaula, is only now, after all these years, finishing its last province, the Western Cape. And I noted that Ambassador Mseleka presents it as some kind of victory. But it is indeed a failure that it took this long. It's only doing so with a target of the 17th of September. Now, Chair, this is not verification. It actually represents institutional failure. And the chairperson of that process has to be held accountable. And as I've said in previous presentations to this committee, that chairperson ought to have long ago been removed. Now, the court ordered registration within 90 working days of receipt of applications. It also ordered the timely processing of healthcare applications with reasons and referral to the appeals board and reconstitution of a functional appeals board within 90 working days. Chair, and herein lies the rub, that on the one hand, the verification of the database has proved itself to be consistently administratively incompetent. But we also deal with an appeals board which is now being put on hold because of the illegality in terms of the way that that board had been constituted. I want to remind you, Chair, that when we had that very farcical and clownish presentation by the Military Veterans Appeal Board, I warned on the record that that board is not legal. I also stated that the existence of that board and the manner in which it had been constituted has to be laid at the door of the current acting Director General of Military Veterans, Ms. Nontobeko Mafu. It is because of her incompetence and the manner in which she had cut corners that this appeals board is not available to military veterans. Now we seem to get an easy way out because a presentation is given to us to say that all of those who have their force numbers will now automatically be included on the database. Chair, while it sounds like a good proposal, I want to raise a red flag here. And I'm pretty sure that the ambassador knows very well that this is the case. Those from the old statutory forces, from the old South African national, or South African Defence Force, actually not national, the national should be excluded from that abbreviation, have their force numbers. It is immediate and easy for them to be allowed onto the database. The people who are going to be severely impaired by this proposal, which is presented to us as an easy way out, are those from the non-statutory forces, those from the former liberation armies such as Umkhonto we Sizwe, APLA, and others, many of whom do not have force numbers, many of whom have not entered the Defence Force in the same way that those from the statutory forces have entered. I'm strongly opposed to any proposal to get an easy, quick answer to the crisis that had been caused by the way in which the database of the Department of Military Veterans has been mismanaged, is now responded in a way that will exclude and, in fact, put at a disadvantage those from the non-statutory forces. And I want to emphasize to the ambassador and to all of us here the critical importance, Chair, of not excluding those from the self-defense units and other what is described sometimes as more informal but less structured participation in the defense of democracy in South Africa, therefore those who are at the core of the liberation struggle in South Africa, and which had been described by the former president of the African National Congress, Oliver Reginald Tambo, as the backbone of the armed struggle and the protection of the people of South Africa during the apartheid era. This should not be tolerated, Chair. Let me ask my questions. which comes out of this presentation by the ambassador. Why do we have nearly 2 months after the committee demanded a detailed implementation plan with timelines and responsibilities and outcomes and monitoring mechanisms, still not a clear, detailed presentation, but we received in this PowerPoint only a high-level presentation with intentions rather than a proper and accountable plan? My second question, precisely how many applications for database inclusion received after the 11th of May 2026 have now actually been finalized within the 90 working day period? And how many remain outstanding beyond that period? And of course, the issue that I've already raised but covered in this third question of mine, what is actually the exact legal and administrative basis for deeming applicants with force and CPR numbers to be automatically on the database? And has this approach been formally communicated and accepted, not only by CMVO SA, but also by the other military veterans associations, SAMVA, MKMVA, and the many other associations that have a vested interest in this issue? Given that the database verification and cleansing workstream under Major General retired Mushaula has still not concluded after years of work, what accountability measures are there actually that are being applied to the leadership of that workstream? And why should we as a committee believe that in September 2026, that final target will be met? And even if the committee, the database cleansing committee, says that they have met their target, that they've actually dealt fairly, objectively, and in a responsible way with the various applications serving in front of them? On what authority and for what period have the activities of the appeals board been suspended? We understand that the appeals board is not legal. We also understand that there's a responsibility by the acting Director General of the Department of Military Veterans for this illegality. And is the acting Director General being held responsible for this consequence, which clearly undermines the court order that requires the board to be constituted and functional in order to be able to deal with the concerns that military veterans had? Has the required consultation within the relevant association under Section 21(1) of the Act been completed? And if the legitimacy of the recent SANVA conference is under evaluation, what interim mechanisms are you going to apply to ensure that veterans have access to an operational appeal remedy? Because this certainly cannot just simply chug along indefinitely any longer. And what concrete steps with dates and responsible officials have been taken to settle the more than 200 million rand debt to the South African Medical Health Services and to introduce a managed healthcare model that prevents further accrual of unfunded liabilities? We had some comparative slides here in the PowerPoint, but no clear answers had been provided. Finally, Chair, all of these issues have to be implemented by a competent Department of Military Veterans and a competent senior staff, which the DMV does not have. We sit with the current Acting Director General who has been illegally reappointed for a further indefinite period by the Minister of Defence and Military Veterans, who's proved herself to be incompetent, who has shown that she cannot act in terms of the needs that there are of military veterans, and who lies at the root of the crisis that exists now with regards to the Military Veterans Appeal Board. Why is that acting Director General still allowed to continue to function there? Because she is not going to implement the suggestions or decisions that needs to be made. Chairperson, I'm concluding with this. The distinction is clear. Technical compliance with a 90-day clock is necessary, but it is simultaneously also not sufficient. We must deal not only with the letter of the law, but the spirit of the court order, which is the restoration of lawful and an accessible benefit system, which by the admission of the ambassador in his PowerPoint presentation today shows that that is not the case now, also in terms of the lack of financial resources available. All of this requires structural reform, a stable and lawful leadership which does not exist in the Department of Military Veterans today. The acting Director General sits in the chair of the Director General illegally and in total contravention of the PFMA. And we must make sure that an operational appeals board gets into place and that there's an end to the verification logjam. Chair, this committee must insist on the removal of Major General Mushwala from the verification leadership. He's failed dismally. We must insist on the immediate removal of the acting Director General from the position in which he has again illegally been reappointed. We must get an appeal board through proper processes that is indeed legal, that can provide monthly reporting and can also make sure that, if necessary, there are further institutional consequences for those who are in the wrong. Military veterans have waited for long enough. The department must now prove its capability of delivering both, not just the letter, but also the spirit of the court's judgment. The ambassador's presentation today was long on the letter of the judgment and trying to find ways to wangle themselves through. It fails dismally in terms of the implementation of the spirit of the court's judgment, which I would venture is in this instance just as important, if not more important. Thank you, Chair.
Thank you very much, Honorable Niels. Honorable Hartin.
Thank you, Chair. Let me just see if I can get that. Thank you, Chair. Chair, the purpose of today's meeting is not simply to establish whether the department has developed a implementation plan, but how far are we in compliance with the Gauteng High Court order judgment. So what we have here is rather more, like in the past, more intentions and less measurable outcomes that have been achieved. So we need to focus on whether the department has reduced the historical backlog significantly, complies with the 90-day working day requirement that was coming from the court order. We know that the appeals board issue will not be in place. And yeah, I think we must all agree the department has presented a more comprehensive implementation plan than in the past. But the documents presented to us indicate that full compliance has not been met, cannot be demonstrated, and the backlog remains substantial. Several reforms are still at proposal stage, and then we have the appeals board issue. So, Chair, what's crucial for us, can we now get an indication which of the provisions of the High Court order has fully been complied with at this stage, which has partially been complied with, and which will not be complied with? We are ending the 90 working day period. So we should actually be, when we get out of this meeting, we should know exactly where we are at this stage, and what will be met and what will not be met. So in a question with relation to the compliance with the 90-day working requirement, can we also, and this is crucial, how many applications have we actually, in terms of the department's interpretation, received after the 11th of May? How many have already now been finalized? How many will exceed the 90-day working days? And what are the reasons therefore? We need to know that. And then the crucial, I'll come to that, the crucial issue obviously remain the backlog and lack of communication thereon. So in the presentation, it was mentioned that at this stage, about 300 applications are being received per week, and that there's a backlog of 8,000. Now, if we look at 300 per week and 8,000, that gives us around about 27 weeks or 6 months number of applications. But we all know that there are many more applications. Honorable Niels referred to applications being received as far back as 2014. I think we need to get the full picture. What is actually going on? What is the age profile of this backlog? What is the oldest outstanding applications? And through the time, and this is also important because we need to know where we come from. The monthly reduction that was achieved, and now what will be the new reduction target? And when, at what stage will this backlog be eliminated? Somebody must know this, and if we don't know this, you cannot properly plan ahead. So we need measurable evidence that the historical administrative failures have adequately been addressed, and that there's a workable plan on the table that it will be addressed. Chair, the automatic database registration. I've got a bit of a different view from the previous speaker, Honorable Niels, on this. I believe this is the first significant administrative and policy change that actually has happened in the department for a long period. And it is certainly not, should not be seen as advancing a certain sector. It should be seen as actually releasing more resources to address the non-statutory component, which requires much more research work, much more work. I think it will relieve the work on the department significantly. It need not take a year to verify data that has already been verified and is there available and is digitalized and is available on a computer. There's certainly no need for any punitive action against the former SADF soldiers, many of whom have sacrificed severely over the years. Chair, moving on. The appeals board. We understand the situation there and the legality of it. The facts on the table are that we do not have an appeal board. We haven't got a mechanism. It's part of the whole process to be legitimized. Part of the court order. We need now a dated plan with targets. And I would like to know how many appeals cases are actually now on the table of the appeals board. How many have been concluded, and how do they accumulate week by week? The court requires an effective appeals process, and we must assess not merely whether the appeals board exists, but whether it actually is functioning or will be functioning effectively. Chair, moving on. It was mentioned that the means test only become applicable after the very recent pension regulations. So, Chair, this certainly is not so. In Section 31C of the Veterans Act, it's provided, and I would like to read it, that where a military veteran is considered for a non-contributory aid by the state, the veteran must be subjected to a means test. That's in the Act. The Act cannot be overwritten by regulations. So this requirement existed since the commencement of the Act and was not introduced for the first time in 2023 in the latest pension benefit regulations. So now the Department previously indicated that, and also in this presentation, it only becomes applicable now. Yet, I don't know whether it's really being applied now, but according to the Act, according to law, this has been in existence for all the time since the promulgation of the Act. So my question would be, on what legal basis does the department now contends that the means test was not required before pension benefit regulations came into operation, notwithstanding the requirements of the Act as it's contained in 31C of the Act? And why, on what legal basis is it implying that it only applies to pension applications after the regulations came into place? The question will then be, what about those applications before the regulations of 2023, 2024 came into place where the means test was not applied? What will be the situation there? Yes, we agree that the actions that now are being taken, where the department will be removing military veterans receiving benefits who are state employees, municipal employees, etc. Yes, that is in line with the same principle as the means test. So what will be the retrospective application be of the mean test to be applied on people who are contrary to the law, contrary to the Act, 31C of the Military Veterans Act, are receiving benefits from the department? So we need clarity on that. Perhaps a legal opinion would be required for this. Chair, I would conclude with that. Thank you.
Honorable Kyle.
Thank you, Chair. Mine is not going to be long. I'm glad because those with force numbers and CPR numbers are going to be in TMV database. But what worries me, there are some members who got file numbers who were already verified a long time ago. I'll be glad if those soldiers with file numbers will be included in those with file numbers and CPR numbers. Also, I would like to add this. How come military veterans, their families are exclusive from hospital or from anything happening in a member? I'll be glad if a member can be included with his or her family from anything. I'll be glad too if those who are qualifying to get pension will be paid, as most of them are suffers are under medication. I thank you.
Thank you very much, Honorable Pele, Honorable Hala, followed by Honorable Munyai.
Good morning, Honorable Chair, honorable members, and colleagues from GMB. Mine just to pass a report. I had a telephone conversation with General Maswala. They will be stationed at the castle of Woodford, Cape Town. He is extending an invitation to honorable members to come and witness what his unit is doing on this verification process. So all those who will be present during that week are welcome to come and join me, because I'll be around that time, to go and witness what actually is taking place in verification. Thank you.
So, Honorable Hala. Honorable Hala.
Honorable Chair, did you hear me?
Yes, I was calling you because I lost you.
Honorable Chair.
Yes, Honorable Hala.
Honorable Chair.
Yes, I can hear you. Are you done?
Hello.
Hello, are you done?
I'm done, Honorable Chair.
All right, thank you very much, Honorable Hala. Honorable Munyai.
Thank you very much, Honorable Chair. And we noted the presentation from His Excellency the Ambassador Tamim Seleku. And firstly, we also appreciate the work that's being done by the Transversal Ministerial Task Team and also General Mashwala. I stand and I think I agree with the proposal by Honorable Hala that those honorable members of parliament may go and see how it's being done. Verification is being done practically so that there's no confusion on the process. And I also, by the way, welcome that Western Cape is the last province, which means the work is nearly being done of verification. So we'll do away once and for all with the issues of the database. That issue will be finalized as this Western province is the last one. I also want to ask some question that I've tried to prepared. So I want to say to the ambassador, one, and the DG, and I know there's been a observed conflict between the PFMA and as well as the court order, but the court order as a matter of law stands, and I want to understand as to what will be the department processes with respect to the applicants with force numbers and CPR numbers as already registered. What is the legal basis for this administrative decision? And the reason I'm trying to ask that question is that it should be followed by how many applicants do not possess the force numbers, and what are the critical arrangements that exist for them to be included. And I must say that though I serve all the people of South Africa, statutory and non-statutory forces, I must say that I'm biased to non-statutory forces because I was one of them and Mr. Mashwala is one of them. So therefore, we can't remove Mr. Mashwala on the program and plus working closely with the transversal team and the department to resolve the challenges of the veterans, because you understand those challenges. How can you vet the military veterans if you're not one of them? So one of the critical issues that I want to put forward, Chairperson, is that I'm very concerned, I must say, that the non-statutory forces, they cannot be excluded on the basis that they don't have the force number. I don't think that was the messaging. And I think there's a mechanism to resolve this issue. So therefore, I will appreciate the ambassador if he could please expand on these issues. Because even though all the non-statutory forces were encouraged to be able to have the force numbers, there were also challenges with the integration of these non-statutory forces at Varanasdal, and as well as the fact that some of the military and non-statutory military veterans or ex-combatant could not pursue military as the career. So some of them, they don't have that force numbers. Therefore, what will be the ultimate solution, Ambassador, to resolve these challenges, to ensure that every deserving non-statutory forces also benefit from what is due to them? I can no longer overemphasize the issues of agency. Moreover, that the court has ruled that all military veterans, qualified military veterans, both statutory and non-statutory, have to receive their benefits. That is the key issues. On the issue of the housing for military veterans, I think there need to be, Chairperson, there's need to be a very major project, mega project, housing project that can resolve once and for all the issue of the housing of the military veterans. We cannot do this at a piecemeal. We must find a mechanism. How do we rope in the DBSA and other development funding mechanism such that that issue of the housing can be resolved, such that the budget that comes from the DMV can continuously complement what has been resolved as a mega housing project, such that we resolve these issues of housing once and for all. I think the presentation has clarified number of issues that I cannot ask. But the critical issue for me is that who will be responsible to make sure that the monitoring and the implementation of this court order, who specifically will be accountable within the department to make sure that the court order is being implemented or achieved within a particular time frame. So that plan and the milestone requires a close monitoring. It is important to understand who will that personally accountable official that will ensure implementation, or officials if it's more than one. That is very important. Lastly, Chair, for me, I'm very concerned about the benefits of the ex-military combatant of the non-statutory forces. It's important. We can no longer delay them not to have ex-medical services. We can no longer delay. We can use Chairperson as a critical proposal. There could be a memorandum of understanding between the DMV and the existing public hospitals across the hospitals, including the some private hospital where the public hospital doesn't exist, that the military veterans didn't have to travel to Pretoria. We know the challenges associated with the 1 meal at the moment. So therefore, a mechanism, a practical and urgent mechanism, have to be made through working relationship, such that if there's a public hospital in the Eastern Cape or in Limpopo or Northwest, they have to go and get access for services in a dignified way in those services. And to some degree, if there are, for instance, certain military healthcare, they can go and service the members, some of them, within this respective area through a coordinated deployment. Chairperson, otherwise I'm very satisfied with the update. And the critical issue is that I'm happy about the progress that they're engaging the National Treasury regarding the additional funding, and to make sure that these issues of funding, which is a chronic issue, is being addressed. And we must deal with them as the meeting has been cleared for us to engage with the Treasury at appropriate program of October. Lastly, as we know, we hope that the NHI will be finalized so that every South African, regardless of socioeconomic status, can be able to have access to healthcare regardless of their socioeconomic status. Lastly, I must say, I'm emphasizing, let's really appreciate the work done by Ambassador and his team, and appreciate the work done by General Mashwala, and reaffirm his continued support in the work that he's doing to serve our people. Thank you.
Thank you very much, Honorable Munyai, and the submissions made by honorable members. Before I come with the way forward, I would request the department to answer some of the questions of the members, especially the ones related to the court order, so that we can get a way forward. Time is against us. It's expected at least by next month, the 90 days will be concluded. I don't want to be called a constitutional delinquent as an honorable member for failing to implement a court order through my oversight role, because any lapse here, it will not be friendly to me as an honorable member who has taken an oath of office to serve the nation and respect and uphold the Constitution. So that would what we request from our officials, to have it in mind that the courts have not been friendly with us as Parliament, especially where we have failed to play our oversight role. And I would request the same to be understood by members, that sometimes when we do this work, we do it in line with the provisions of our oath, which is bigger than our parties, because an oath deals with our level of patriotism and national interest. So there's the understanding that I would request from all of us, but also the cost implication of individuals and severally. And in case this case is further pursued and costs are required individually, it can hit on us as members of Parliament. So I think it's very much important that when we deal with such sensitive matters, we also take into consideration the possible implications for us in case the court or the prayers of the applicants would want to punish us as individuals. But it's a matter of discussion for another time. I would request the Honorable DM, His Excellency, and the Acting DG to respond. Over to you.
Thank you. Thank you very much, Chair. Chair, thank you for the inputs that have been made by the various members and the questions. Some of the inputs are for further processing because they are actually related to the broader questions of addressing the challenges facing military veterans. So let me deal with those that are specific to the task at hand. First of all, Chair, we made a distinction in the input between the processes that have been followed with regard to non-statutory forces and the processes that have been followed with regard to the statutory forces in terms of dealing with their applications. Precisely because the non-statutory forces do not have force number. That is why the DVCE was established in the first place. It was to use a different verification process because then it required different kinds of approaches and evidence to ensure that people who are properly applying are actually indeed military veterans. And that grew from some experience, which I'm not going to get into. So those people were given a chance to apply, and the applications, those that were excluded from the processes that Honorable Munyai has referred to, were given an opportunity to then make their applications, which is why it was opened in the first place. Otherwise, the matter would have just ended at integration and said people were integrated. However, it was opened for them to apply, and then a process established for the DVCE to actually go around provinces to interview those people so that they could actually finalize the process. Now, Chair, we are saying that from a point of view of all those that actually applied who were a backlog, they have gone through all the provinces. They have actually interviewed those that made themselves available. They were informed that the verification committee is in the provinces. Those that made themselves available were actually dealt with, and including even those that are said to be in the context of SDUs and other internally trained people. They didn't chase anybody away on the basis of that. They dealt with the people as individuals and listed those that they from their interviews actually concluded that these are SDUs. Now, Chair, there's no administrative process in government that doesn't have appeal mechanisms. So anybody who applied even through that process and was denied and feels that process was wrongly concluded, the appeal mechanisms that are available also to the non-statutory forces are the same appeal mechanisms, so they can still appeal that process, except, of course, the category of SDUs and so on, because, as I said, that's a matter of government policy that government needs to take decisions on. And therefore, it will be referred to proper mechanisms of the PTT, which will then finally decide what to do with those matters. Chair, anybody who feels left out from the non-statutory forces, either because when the process reached their provinces, they were not there, they were not contacted, etc., etc. Anybody who's actually left out in that process doesn't mean the process is being closed. We are dealing with two aspects. One, as directed by the committee, how do we deal with the backlog? So in other words, the backlog we are dealing with means those people who have already applied, they are in the system of applicants. And now how do we actually finalize their application within the 90 days, within the date of the 90 days given by the court? And what we have described, which is to say the process that General Mashwala is involved in will be finalized within the 90 days, because the 90 days ends in September. So we are going to meet that deadline because the committee is now doing the last of the provinces. That does not mean that it closes at this point. It doesn't mean that it closes the process of considering applications from those people who still believe that they have not had the opportunity to apply. Those that want to appeal can still appeal, and those that feel they were left out in the process, it doesn't close their possibilities. And again, the outline of the public announcements that are going to be made at the beginning of September will also outline the processes regarding those. In other words, we need to reach closure, Chairperson. Of course, if by now we haven't been able to reach all those that are really supposed to be part of those formal forces, as have been referred to, after 30 years and they have not really made the applications, there must be some kind of closure on that process. The only closure that perhaps you might not have is this discussion about SDUs, internally trained people, etc. That's still a conversation, and maybe more people may come forward. But anybody who was actually formally in Umkhonto weSizwe, formally in APLA, in Azandla, by now should be getting the last opportunity to be able to come forward and say, I feel I've been left out and therefore I must be included. These are the reasons. And the process is still open for them to actually approach the DMV through the processes of application, of appeals, etc., etc. So the notion that one is advantaging one group and not the other, actually they are being dealt with both in the same way. The backlog that has to do with the 8,000, which we are now talking about false numbers, does not mean that we are talking about all people, non-statutory or statutory. The non-statutory comrades or people who are part of that category, they have a process which we have been dealing with in terms of them, and that process continues. The backlog has been dealt with by September. But as the court said, if you receive an application, you must deal with it within 90 days. So those people who will still be saying I've been left out can still approach the DMV, and they will be dealt with within the period of 90 days. The court order of 90 days doesn't end on the September 17. The September 17 is dealing with those that were already in the system by the 11th of May and before, in terms of the backlog. Beyond that, applicants, as I said, even within the statutory forces, there may be people who may not have forced numbers for one reason or the other. One of the members referred to files, where, although I don't really understand what he meant, but if that is a legitimate process, those people still can be dealt with within the 90 days of their application. So, Chair, just to take out the notion that there's anybody who is included by the proposals, we have said that the backlogs for the non-statutory will be finalized by the end of the September 17 by General Mashwala. They'll still need to do some kind of cleanup process here and there, but finally the backlog would have been actually dealt with from the applications that we have on the table. We can give figures as to how many applications they started with, how many they have finalized, how many have been approved, and how many have been rejected. Therefore, how many possible appeals are going to be there. Those figures will be given at the stage where we close the process of the 90 days. They are there, they are actually professionally done. The question of whether they've taken long or not, whether it is actually the function of General Mashwala or the function of the system was in place, is still a question mark that has to be discussed. So we cannot really just put the blame on General Mashwala and say they've taken so long. I think we need to be informed first before we make those conclusions. So, Chair, that's the first matter I need to clarify. Secondly, which means, therefore, even the questions that are being raised by honorable members, I think Honorable Harting wanted to know how many people applied from the 11th, how many have been finalized, and how many are still outstanding. I think honorable members must actually see all that within the context of the committee saying, don't tell us about the applications that come from the 11th of May to the 17th, because that's not the spirit of the court order. The letter of the court order might be saying that, but the portfolio committee itself said, no, we want you to deal with all applications, whether they are coming today or they came 11th of May or before. So the response we are giving says, even those that applied on the 11th of May and are to date now waiting for their responses, which in fact they are entitled in terms of the court order to receive before the 17th of September or by then, even they would also be included in this context of those that actually have forced numbers and CPR numbers. So when we make the final declaration, and that's not an intention, it's a plan. The plan says, first week of September, we will announce that all those that are actually having CPR and forced numbers are actually now deemed to be already on the database, and from then on, they can then apply. They are invited to apply if they want, they so wish, for the benefits. They are no longer having that obstacle of not being on the database, because they will be on the database as such. So it's not necessary for us to distinguish between those that applied on the 11th of May and those that are going to be applying maybe even after September. Only those that will apply after September or after that declaration will be those that actually feel they don't have CPR numbers, but they're also not non-statutory, because the non-statutory ones will also do their applications if they feel they've been excluded. They are also part of the 90 days going forward after this announcement has been made. So that is the plan. And therefore, the backlog by then will actually be almost zero, because from the non-statutory forces, all the applications that would have been sitting with the General Marshall would have been dealt with, except those that did not appear. And it's their right to be able to say, for this reason, I wasn't able to appear, therefore, I want this matter considered further. It will be considered within 90 days. And all those that have false numbers or have applied will be considered again. So that clears that issue, which means compliance with both the letter and the spirit, at least partially, of the court order is actually being dealt with in this response. Secondly, there are matters that relate to the appeals board. On the one hand, members concede that the appeals board is actually not legally appointed. On the other hand, they would want to know how far the appeals board is. The appeals board is not far because it is not there legally. From the point of view, when it started doing its work, we had to stop it because whatever decisions they were going to make would have been deemed to be illegal. Because the body is not legally constituted. So there's no way we can give an update on how far they are, or because they haven't done any work. It's as if they didn't do any work because they are not legal. So members would have to actually contend with that. And we are putting mechanisms, as I've explained, to be able to ensure that they are legally constituted within the time frame that the court has actually given us. So in other words, our target is that we will explore all other mechanisms, including even consultations with the current SANVA and perhaps ratification later, if we are not able to deal with the legality of the SANVA currently, in order to ensure that those members can start working by September again, whether it is in the same format or there are additional members or there are changes, but we are confident that the committee will actually be will be there in place on time. The only matter that we want to emphasize, and the rest, as I said, Chair, we can only perhaps give all those details in kind of follow-up questions. But the only matter that I want to deal with is this issue of the means test. Honorable Harting is correct. The legislation says they will be subjected to a means test, but it doesn't say what means test. What is the means test? What is its specificity? Because those matters are then elaborated in the regulations. So to give effect to the law, the regulations have to then say this is the kind of means test you will be subjected to. Up to now, that regulation did not have the specific means test that people would be subjected to. So it didn't say, for example, that you have this income, you won't qualify. If you have this, that, and the other, you won't qualify. The only means tests that were applied were those that are already applicable by other laws. For example, in the Pensions Act, you cannot actually receive pensions twice or what have you. Those are normal. They're not in terms of the means test that is actually envisaged in this act. So the regulations, which is what is new, that's why we're talking about the new. The means test as a mechanism, as a basis, was there in law, but it was not actually implemented through regulations. So the regulations are now implementing what has existed in law but was not implemented. So it's not superseding the regulations, it's giving expression to those regulations in terms of effectiveness. So the question then of retrospectivity, whether now, because there's this means test, can we apply it retrospectively? Generally, let me say 80% or 90% of legal advice says you cannot do such a retrospective kind of implementation. When you approved me, that hurdle did not exist. However, it's not stopping us from actually, as the honorable member himself is suggesting, from actually establishing the legal basis so that everybody is clear why we are doing it or why we are not doing it. Because the question always arises, but you must apply it to those that have been there in the past. So for us, it's not one thing to simply say verbally that legally speaking, you can't do it. We have to have a legal advice. So we need that legal advice, not because we want to be able to do it retrospectively only, but because we want to assure people who ask that question that it is not possible to do it from a legal point of view. So that's where we are with that matter. Chair, let me not deal with the individual issues that have been raised because there are many, but they are broadly within those themes. And let us assure the committee that the process that we're undertaking is addressing both the letter and the spirit of the court order and the spirit within which the portfolio committee is trying to intervene on these matters, because the view is that the matters have been on the table for too long and the people that are impacted upon have been suffering. So we're also trying to deal with them in a fast-track manner. Fundamentally, at the end of the day, this will boil down to the resources that are available for that. The administrative problems are being eliminated, as you can see, and we're eliminating them as fast as possible. But the fundamental question of whether the state has the resources, that would have to be a discussion with the relevant authorities of the state, which we are doing on our part, but the members may also suggest, as they are suggesting, that they will be engaging on that question. Therefore, if I don't answer the individual questions, it's because of time, Chair, but let me just deal with those broadly because they more or less cover all the ground of the members who have raised the questions. Thank you.
Thank you very much, Your Excellency. I'm sure members, it gives us an opportunity of the way forward on the matter. From my side, I think we will have to make a follow-up on number of issues that were raised by members, which I don't think they need us to talk in this meeting. The one point that was raised, it was on the program which is run by General Mashwala. Members have been asked to attend the Western Cape verification to see for themselves of what is done. I'm interested, but I'm not sure whether the dates would suit me. I'll have to make a follow-up because there are things I want to ask the general from, because I don't think the process as it is, especially in the case of non-statutory forces, it covers all frontiers and it covers all the pillars. In the underground structures, there were 8 frontiers and there were 4 pillars of the struggle, which not all of us come from the underground structures, but there is one way or the other through internal mechanism that we can be classified as military veterans. And I think in how the act was conceptualized, the 8 frontiers as well as the 4 pillars of the struggle were not taken into consideration. And that's why there would forever be a dispute of who actually is a military veteran, because by definition it's not clearly defined by the act. And I think it's a matter that we have to look at as part of the work, Your Excellency, in terms of reviewing our definitions so that we are upright in clarification of who's actually who, because the biggest problem in verification is not with statutory forces, it's with us non-statutory forces because of how we're structured, and if the current legislation does not appreciate that structuring, it's a problem, because there are some and many of us who appears on the TRC reports as having done military operations. But in the General Mashwala's process of military veterans verification, we have been disqualified. And I don't think which method is he using. Does he use a TRC report? Does he use a biography? Or which methodology is he using to verify who was the actual military veterans? Because, for instance, in my case, I was in the Liliengo internal unit. And if I go through General Mashwala's process, it may be found that I was not part of any unit which was in exile, when actually some of us were internal. We never went to exile. It will be a lie to say that I'm from Angola or Zambia. I don't want to go to that extent, but I think that we can do by clarifying or enriching the act, because it's a problem. So I think let's look at how we review our definitions. The issue of the acting director general, I'll give it to the executive, not even in this meeting. The DM, you can take the message to the minister just to clarify us, or either even ourselves through our parliamentary legal services, we can clarify ourselves either through a legal opinion to check the legality of further appointment of acting director general, whether it's within the Public Service Staff Code or the laws of our employer-employee relations contract. Does it allow it? Because acting now in the Department of Military Veterans is now going for 11 years, and any contract of employment for that senior position is 5 years. We know she may not be the first one to act, but acting has been continuing unabated in the Department of Military Veterans. So you can either confirm it or finalize your process of appointments, but I don't think from our side as a portfolio committee, we can agree on further acting. I am also not comfortable with that story of acting, but I will write to Parliamentary Legal Services to check for us. If it's found that we are wrong, we're going to inform you. If not possible, we'll refer this matter to Parliament for ethics and other matters, because we can't continue our relations if others are not going to respect the rule of law, because that's what we are expected to do by the oath we have taken as members of Parliament. The issue of the appeal board, I think it's a matter under construction. We will deal with it according to further reports that the executive would decide on in line with the court order. The housing project, Honorable Munyai, I would request that you do a proposal. We are meeting with human settlements next week on the 12th to discuss the encroaching of military bases, including alternative housing that needs to be done by people who will be moved out of our military bases. So the Department of Human Settlement, together with municipalities, can house them. And I think because we're meeting human settlement, we can put in our proposal of housing allocation to our military veterans, because the quantum they are giving us in terms of numbers of 700 or 600 per annum, when we have an estimated database of 14,000, it means at that pace, it will need us another 30 years to fully give our military veterans their benefit of housing, and most of them are more than 60, 70 years, some more than 60 years. And it's clear that even in the next 5 or 10 years, some of them will not be available and they will not have even benefited. So I think let's bring it next week to our engagement with the human settlement, so that we deal with this matter once and for all next week in our meeting of human settlement. I just wanted to take this opportunity to thank the department for the presentation. We are now going to move to the second presentation that deals with the financial report as well as the performance report of the Q1 of the DMV. I'll hand over to the DM. DM or Acting Director General.
Thank you, Chair and honorable members. The presentation will be done by the CFO. Thank
Chair,
you.
I've raised my hand on a point of order.
Okay, point of order.
Chair, we are being introduced to this particular presentation by the Acting Director General, who's illegally in her position. That is unacceptable. In terms of the protection of yourself and all of us in this committee, I ask you to rule, Chair, that the Acting Director General not participate in this meeting. You said you will get legal advice from our parliamentary legal advisors. As far as the economic freedom fighters is concerned, the legality issue is clear. The Acting Director General is illegally in her position, and we compromise, all of us, you yourself as Chair, I myself as a member of this committee, in fact, all of us in this committee, to engage with her in this illegal position that she holds. That means that we actually ratify and agree on that illegality, and it makes us criminally liable, all of us, as we are present here. From the side of the economic freedom fighters, regardless of the legal advice that you intend to get, and I applaud you for wanting to do so, we intend to institute the necessary legal action in order to now get the acting Director General, illegally appointed as she was, removed, and for legal action also to be taken against the executive, specifically the Minister of Defence and Military Veterans, who in terms of her reappointment of the acting Director General has contravened the PFMA, has acted illegally, and therefore herself is also criminally liable. I ask you, Chair, to ask the acting Director General, and I put that in quotation marks, that acting, or Director General, because she is illegally here. She is not due to be with us. I ask you to ask her to recuse herself from this platform before her presence here compromises all of us and make us all legally liable in the future. Thank you, Chair.
Thank you very much, Honorable Niels. Before I rule, can I give to the Honorable DM as the head of the delegation, Honorable Mukungo?
Yeah, we note the comment from Honorable Kalni House statement, but however, we feel it is unfair to just say so in the meeting, in the middle of the meeting, towards the end of the meeting, you know. But we know that, and as a department, we are going to engage on that and come back to the portfolio committee in our next meeting.
Okay. Yes. Are you done, Honorable GM?
Yeah, yes, Chairperson.
All right, no problem. I think let's do it this way. I think we'll allow any party to reserve their right to take this matter legally in case there's any matter that the executive needs to answer to. From our side as the portfolio committee, we'll make further inquiry with the parliamentary legal services to check for us on this particular matter. But I think it's just unfortunate that Ms. Maf were to go through this, especially when she did not do this on her own accord. She was appointed to assist the department at an acting capacity. So the concern that is raised by honorable members, we cannot also downplay it. If she has been acting for over 2 years, when legislative prescripts are clear on how long can an official or a senior management official act. So let's await the legal opinion, and let's also await the executive to come back to us, as the DM is saying that they will look at it and come to us. What I will do for now is to allow the CFO to present the Q1 performance and financial report, whilst the matter of the acting Director General will be dealt with. I would not ask her to recuse herself for now, because she has been appointed by the executive authority, and we would not want to encroach on the power of the executive until we get a full legal opinion on what needs to be done as a way forward from our legal services. And that's what I would request from members, so that we allow the executive authority to make decision and exercise their right in terms of separation of power, whilst on our own, as an authority within the separation of powers, it's making our decision and consulting. And if it's found that the executive erred, we will then act as the legislative arm, because we cannot allow any disrespect of the rule of law by the executive authority. which is accountable to us in terms of the provisions of Section 55 of the Constitution of the Republic. I will now allow the CFO.
Honorable Chair, at the
Yes.
beginning of this meeting, I said that I will have to excuse myself by 12:30, and I'm actually very happy that that time has arrived now, because I disagree fundamentally with your decision to allow Ms. Mafu to stay in this meeting. And under the circumstances, I will then leave this meeting, not just because I said that I have to leave because I've got other commitments, but also I do so officially on behalf of the economic freedom fighters, because we are not going to legitimize the presence of an illegally appointed person in a meeting here. And we will, as you said, take our further legal actions and advices, and we look forward to also receive the legal response from the parliamentary legal advisors. You know very well, Chair, that we deal here with a matter of utter illegality that has been going on for years, which we warned about, and this is a flagrant flaunting of the law. I thank you. I thank you for your decision to get legal advice, but at this point, I see no other way open for myself and my party to recuse ourselves from continuation in this meeting. Thank you.
Thank you very much, Honorable Nias. We respect your decision and the fact that you reserve your right as a party to take legal action or to raise your matters with the Ethics Committee or any other committee of Parliament in case there is an error of judgment from the Executive Authority in further appointing the Acting Director General of the Department of Military Veterans. No, your point is taken and noted.
Thank you, Chair, and goodbye.
Bye-bye. CFO, you can proceed.
Chairperson, did you see my hand?
Okay, Honorable Ate. All right, you can proceed.
Thank you, Chair. Thank you for your opportunity, Chair. Thank you also for the undertaking to get a legal opinion from the parliamentary legal services on this issue. But the Chair, it goes a bit further, and I would request that you also look at the legal implications of what we're about to do. The acting DG is the accounting officer. What we are about to now engage on is a report from the accounting officer. Also, what is behind the history as well as in the future. So if the position, and it is found that the position of the acting DG is, which is indeed is above any doubt now under question, is in fact illegal, then that will also cast a doubt on what we are now to do, which is in fact the work of the accounting officer under her signature, what we now have to engage on. So I would you please also request that you also put to the legal question also the legality of this meeting and the work that we are about to do, and that will arise from this committee, from a report from the accounting officer.
Okay. No, I think the point is noted, Honorable Aten. Yeah, we will have to do that particular exercise also to check the legality of receiving this report. I need to put it upright that in case the legal opinion says something contrary to what the executive would have done, it means this particular process will be null and void if we are to conclude finally from the parliamentary legal services. So for now, we'll allow the Department of Military Veterans to present through the CFO with that particular question mark of the legality of the report in case it is found that the acting capacity of the Director General is wrong. For now, we would not want to encroach on the powers of the... what is happening now?
Morning, Abba.
Honorable DM, can you switch off your mic? Honorable Mukungo? All right. I'm saying that we'll allow the CFO to present pending the outcomes of the legal opinion in relation to the acting capacity of the Director General, so
Chair.
that we don't encroach on the...
Chair.
Yes?
Chair, I'm a little bit puzzled on the approach that we are taking.
Yes.
If you say you've already decided that the CFO is going to lead the presentation, you've already decided that the acting DG is not going to lead. So what is the implication thereof? So you, as much as you are leaving in the meeting, you are saying she's not going to present. Shouldn't we rather stand down with this presentation and have it another time until you find full legal advice? Because you are making a decision now that the CFO is going to lead, although you are leaving the DG in the meeting, and until you're going to get legal advice, what are we really doing? Can we not rather stand down on this matter and let it be dealt with in another occasion? That is my question, Chair.
Yeah, look, Honorable Plakis, I don't want us to put a person on this particular presentation. I would want us to deal with the Department of Military Veterans. The decision to have the acting Director General, it's a decision of the executive authority, which is the minister. Now, the portfolio committee and members are challenging the further extension of the acting Director General. Now, in that persona of the acting Director General, it's Mrs. Muff. Now, she did not appoint herself. She was appointed by the executive authority, which is today not in the meeting. They have put in an apology, both Honorable Olomisa and Honorable Minister. Is the Honorable Deputy Minister who's here, who is a deputy to an executive authority. He can't tell us here with authority that this was the reason or the rationale behind his appointment. But besides, we also don't have a legal opinion from our legal services whether this is wrong from the side of the executive or what. So to punish her and remove her out of the meeting, it would be wrong. That's why I'm saying once we have a legal opinion, it would be correct that if it is said by the legal opinion that the appointment it's problematic, then at that stage we'll then nullify the process of today. And that's why I would not want us to make a ruling that says no to the presentation, because it will be like we are encroaching or entering into the authority of the executive. So let's allow processes to be undertaken, allow the presentation to be done. If it was wrong, then at that stage of the opinion or of the decision, we would then know that it was wrong, and as a result, the presentation would not have effect to the work of the portfolio committee. So that's why I wanted us to do, because if we nullify it now, it's like we are undermining the authority of the executive, which is not the intention. The intention is to get the rule of law to be respected. The intention is for us to play our oversight role on the executive, and the executive can't bully us. So up until we have all the facts before us, is then that we can make a conclusive decision. But for now, I did not want the portfolio committee to play a judge in a case of the decision by the executive. Are we together, Honorable Plakis? Honorable Plakis? Honorable Plakis?
I'm fine, Chair. I'm fine.
Okay. CFO?
The DM's hand is up.
Oh. The DM hand sits up, Honorable DM?
Chairperson, I felt that it will be wrong to approach this matter in this manner, because we are here and acting DG did not appoint herself. She was appointed by the executive authority. Whatever wrong the portfolio committee notes, we are saying we are going to account in our next meeting. Therefore, I don't see any reason to say towards the end of the meeting she must excuse the meeting. It is wrong, Chairperson.
No, I fully agree with you, Honorable DM, and that is my ruling. So you are seconding me. It's okay. Thank you very much. CFO?
Good afternoon, Chair. Good afternoon, all honorable members, DM, Ambassador, Ms. Mafu, and the colleagues. Just want to confirm, Chair, from the time allocated any specifics in the interest of time, considering that we already at 12:30, so that I can pace myself accordingly, Chair.
No problem, CFO. You can just summarize your Q1 report. It's okay. All right.
Thank you kindly. Thank you kindly, Chair. In terms of performance, in terms of a financial position, I think the ambassador has done justice on behalf of the department. So we will just quickly summarize the performance by looking at the slide in front of us, Chair. Just to confirm, Chair and honorable members, as per the current tabled APP, we were still reporting against the percentages. We note the directive provided by the portfolio committee that which the department should consider reverting back to absolute numbers. This performance of 73% achievement, or 8 out of 11 achieved targets, was mainly based on what we had targeted for Q1. You will recall, Chair and members, that in our APP, certain targets are then targeted outside Q1 from Q2, Q3, and Q4. In terms of comparative to the previous financial year, Chair, based on the current performance, we then see an improvement of around 36%. In terms of performance by program, for program 1, which is administration, we have noted that for Q1, we have achieved 67% compared to the 40% achievement in Q4 of the previous financial year, which represent 27% improved performance. For program 2, which is social database and social economic support, we are reporting a 60% achievement versus a 57% in Q4, which shows a slight improvement of 3% versus the Q4. And then for program 3, which is empowerment and stakeholder management, we are reporting 100% achievement, which is a 57% improvement versus the performance of 43% in the previous financial year. Just to probably emphasize a point without attracting further questions from the portfolio committee, what we are then reporting using percentages, it mainly was around the fact that we are not in direct control of certain key performance areas, and hence then we were advised to then also consider using percentages. And probably it's one of showing improved performance. However, Chair and members, behind these percentages, there is a detailed report that shows the actual absolute numbers in background, which those numbers are also part of our technical descriptor indicators, which then shows the basis of calculation. So for Q1, that detailed report, if not already shared with the portfolio committee, it is always available for the portfolio committee to have confidence in the numbers that we are presently reporting using percentages, Chair. Thank you so much. And then probably we will pass this slide because it's just the same information presented in the graphical format, which then shows historical performance for Q1 specifically, commenting from the 2020-21 financial year to the Q1 of the present financial year, Chair. Probably just concentrating on the key areas where we may have challenges. I will just concentrate on the key shortfalls. For PPI 103, which is the achievement of the ICT strategy, that is probably the one challenging aspect in terms of the administration branch. We then, as a department, we are working with MENCO to ensure that all the pillars of the ICT strategy as targeted will be achieved. Then in program 2, probably the key challenging areas are the mortgage bonds, where there were no assessment because whatever was submitted to the department, the documentation was incomplete. And therefore, we did not have a denominator to then derive the percentage achievement. Lastly, in terms of healthcare service delivery model, probably we do have an issue which is currently is operational, but that will be then discussed in the upcoming MENCO, which will be held this coming Friday, Chair. There were no challenges in particular in program 3. And in conclusion, Chair, in terms of human resource management, Chair, we are working through the TMTT now with the DPSA. We have since, through the intervention from both the TMTT and the PTT, won the heart of the DPSA. And we do have a working committee now working flat out on the organizational structure for the department. And it's got strict timelines, which works up until the 31st of March of 2027, upon which then we anticipate to have had an approved organogram ready to be filled in through the normal prescribed public service regulations, which says each position must be job graded and then advertised and then be filled in a proper manner. And in summary, Chair, just to confirm in terms of this slide, Chair, the bullet 2, the 204 expenditure, sorry, there is a mistake here, Chair, was 22% of the total appropriated expenditure, Chair, of 912.8 million. And also in the bullet point number 1, 2, 3, 4, 5, the current budget of 172 million will be depleted by November, Chair, not by August. We have recalculated based the current going rate, which then determines that this current budget will be depleted by November. So we are working through the TMTT and the Executive Authority by engaging National Treasury so that then we can cost the current regulation, as well as then determine the full funding requirements for the military veterans pension, so that then the permanent funding model is canvassed. We note the upcoming meeting of the committee with the appropriation committee, probably through the executive authority, we may smuggle our proposal for funding of the military veterans chair. As well as Ambassador has also indicated the current liability and cost pressure on the side of healthcare benefit chair, because the current determination by Treasury is to say we will fund from the current allocated resources. Even over the MTEF, there won't be additional funding. So probably then interventions may be sought through the executive authority, going through the portfolio committee when necessary. In conclusion, Chair, that will be it from the department side. Thank you, Chair.
Thank you very much, CFO. You are allowed to submit to us your financial request for our meetings of the 26th of August, when we meet Treasury and Appropriations Committee, because it's going to assist us to put up a case, because in terms of our legislative architecture, it's us as this portfolio committee that must help you raise funds with Treasury and with appropriations, because it's us through Parliament who approves your budget, who approves your allocation. So if we know and better armed, at least we can do our work better. So that's why I still want us to engage so that we deal with this matter. I would allow members to come in if there is any submissions from honorable members on the presentation of the Q1 financial report and performance from the DMV. Any submission, honorable members? Okay. If there is no submission, I'll make the following points. That indeed it's correct, CFO. Can we get that submission from yourself to our secretariat on things that we need to engage the Treasury and appropriations on from your side? Because I have seen that the department and the portfolio committee's relations for the past 15 years has not been that of lobbying, facilitation, and engagement, and I would want us to improve on that. Make those submissions to us, who are the authority that must help you to get more budget allocation. Would appreciate to get that. The second point is that the secretariat will have to make an application with the speaker or the chair of chairs on us having the meeting of the 26th of August as a closed meeting, so that international foreign spies don't listen to our engagement in terms of the budget allocation of the National Defence Force. I think it will assist us so that we don't make our meeting public. In relation to the court outcome, we will get a progress update by September or earliest our next meeting, in case there's anything, but we wish the department well in engaging with the court on what is possible and what is not possible in terms of provisions of Section 38 and Section 39 of the PFMA. But it is in our interest as the portfolio committee that we comply with the Act, because it's now 15 years since we had this DMV Act, and 15 years later, we've not even finalized the database We have not even finalized the implementation of all benefits as outlined by the Act. And what I would request from the side of the Portfolio Committee that the department work closely with all military veterans organizations so that we'd rather engage them than them taking us to court and getting more and more court orders because it's clear that we can't win any case because we have failed to implement our own laws. And as a result, I don't think we'll get any sympathy from any court because it's not out of a mistake of the veterans. It's out of our failure as the department to implement the provisions of our laws. And I don't think we'll get the sympathy of the judiciary. So that particular matter, the only thing we're left with is diplomacy and engagement of all military veterans association or organization to get it better. On the matter of the acting DG, I think we have agreed on getting a legal opinion, but I would want to caution my members to understand that the minister or an executive authority is not a member of the portfolio committee. So a minister or an executive authority, it's an authority of the executive in terms of separation of powers. We play oversight on them. We can't encroach on their work, on who to appoint, when. We can only get into their work to say whether compliance in terms of the rule of law was done, and that is done through oversight. But we can't want to impose ourselves to say acting DG must not be in the meeting. We don't have a contract of employment with the acting DG. We cannot also say the acting DG can be here. She's not suspended, and we're not the authority that can discipline her. So I think we must also know our limitations so that we don't get into a situation that can create legal questions, and it can create a problem of relations between the executive authority and the legislature. So I would humbly request that we allow the executive authority to come back to us with answers, but in our own case, as the portfolio committee, we reserve our right. We will ask through our parliamentary legal services whether what the executive authority is doing, is it correct or what? And I'm sure at that stage we would then be able to make an informed decision rather than undermining contract of employment, labor laws, separation of powers. So I think we can do better. So let's allow it that process. The acting DG is there. She's not suspended until the executive authority comes back to us. So the DM has also explained it. So I think this, if there are no questions from members, it brings us to an end of our meeting with the DMV. We can remain behind.
Do you see my hand?
All right, Honorable Aten. Yes.
Thank you, Chair. I've got some questions. Chair, firstly, as far as the performance indicators are concerned, this is exactly the problem that I also put to the meeting, to the department when we address the APP. So what we have, we are going back to the percentage issue. Percentages alone do not enable us to assess the scale or impact of service delivery. And we certainly need that. And we also need to compare how these figures that we now are being exposed to, how do they actually compare with Q1 of the previous financial year, as well as the previous financial year? And on this basis, we simply cannot do that. So, Chair, well, what we need for every performance indicator will be then the annual target, Q1 target, actual numerical achievement, not percentages, the variance against target, and most important, the actual number of military veterans who benefited from this. So we need, for instance, to know during Q1, how many military veterans actually were registered on the database, how many received benefits, healthcare benefits, military veterans pensions, housing support, education support, business support, and employment support. And Chair, most important, how do we compare this then, and how does it compare with the previous quarter ones of previous financial year? Chair, we need that, and I actually told you in that meeting that the way that the department is reporting on this is deficient. We cannot get the actual figures. So, Chair, I know the 7-day rule is not really applied, but in this instance, I insist that it be applied and that we get the responses in writing. Thank you, Chair.
Okay, thank you very much, Honorable Harting. I'm not sure the department, is there a reason why we can't get figures? Because in the past we have requested that instead of percentages, let us get physical numbers, which says we've got 15,000 military veterans. These are the benefits which has been allocated to this number in quarter one, housing, this number, health, this number, all of them, pensions, this number, so that we know exactly the impact of the work we are doing. Is there any rationale or reason? Can we get clarity before, whilst we are still waiting for a written reply?
If I may come in, Chair.
Okay, CFO.
Yes, in terms of our reporting to the DPMA, we do in background a very detailed report, Chair. If not already submitted to the portfolio committee, we can even share today so that we can demonstrate that the numbers sit behind the percentages. Thank you, Chair.
Okay, thank you. Thank you very much, CFO. I'm not sure before I leave any hand behind. In case of no hand, let me release the department and release all of you. Thank you very much, Honorable DM, Acting DG, the entire department, Your Excellency, and all the support staff members from the ministry. Thank you very much. We are going to remain behind as a portfolio committee to deal with our in-committee matters, especially our minutes. Thank you very much. Secretariat, can we go to the minutes? Consideration.
Thank you very much, Chair.
Thank you very much, DM. You're welcome. Thank you very much, honorable members. Those are the minutes of the Committee for Defense and Military Veterans. It was on the 10th of June. Can we go through the minutes? Scroll down. Secretariat. Am I audible?
You are, Chair.
Am I audible?
You are, Chair.
Okay, can we scroll down the minutes? Secretariat. Amanda.
Yes, Chair, I'm trying to scroll them down. I'm facing network challenges. I'm trying.
Are you not in Cape Town? Cape Town is 5G. Ogu Bezlale. Page number 1. Page number 2. It's the attendance register. Page number 3. Page number 4. That's where they start. 5, 6, 7, 8, 9. Any matters arising from the minutes? Any matters arising from the minutes, honorable members? In the absence of any matters arising, can we get a seconder, a move and a seconder?
I will move, Chair.
So I move, Chair.
Honorable Lating moves, Honorable Hala seconds. Uh,
Those are the second set of minutes, Chair.
Hello?
Yes, Chair, we can hear you now.
Okay. Can you hear me? Okay, just scroll down the minutes. We are still on page 1. Scroll down. Hello? Okay. Yeah, page 2. Can we go to page 3? Page 4. Page 5. Page 6. Any matters arising from the minutes? Honorable members, in the absence of matters arising, can we get a mover and a seconder for the minutes?
I move, Chair.
Honorable Adam moves. Can we get a seconder?
Second, Chair.
Honorable Cele seconds. Any further minutes? We've got minutes of the 24th of June. Page 1, page 2, page 3, page 4, page 5, page 6, page 7, page 8, page 9. Any matters arising from the minutes?
Chair, can we just go back to the bottom of page 8, please?
Bottom of page 8.
Chair, there are 4 bullets there.
Yes.
Whether that, have we received those? The matters that are contained in the resolutions, there are 4 bullets. Was it received?
No, we have not received them. Secretariat?
Not yet, Chair, but I will remind the department after the meeting.
Chair, this is standard operating procedures. We take resolutions, it goes nowhere, nobody complies. There's a set date here, 31st of July. It was ignored. Now we will record it again. It will appear in the next minutes, but still, I can assure you, and I base this on the past, that we will not get this. We cannot continue like this, Chair. This is been the practice, the modus operandi from the department. We ask many questions in committees, in our committee meetings, engage with them. They do not respond to the questions, undertake to submit it in writing, and then nothing happens. Well-established practice over more than 2 years now, Chair. It cannot continue like this. I would like to know, how are we going to address this, as well as other historical outstanding reports and responses from the department?
Yeah. Look, can we make a follow-up, Amanda, on these ones? Including of today, we've given them 7 days on other things that we discussed earlier. I don't mind, I can write letters this afternoon to them back, reminding them on all these decisions, because we're being on resource. I don't think we made a follow-up on these ones. Let's make a follow-up so that we remind them of the work we have written to them. It's only for them that to reply to us. You're correct, Honorable Harting, that they have not been cooperating with us well as the portfolio committee. Okay, let's do it like that. Amanda?
Understood, Chair.
Chair, may I request that this committee receive a report on this issue, the 4-year bullets, as well as the outstanding issues within 7 days. Thank you, Chair.
All right, thank you. Point taken. I would request that Secretariat that immediately after this meeting we work on these letters. We'll also make them available to committee members in our portal, or what is it, in our group. Okay. Can we get a move and a seconder?
I move, Chair.
Okay. Honorable Harting moves. Seconder? Honorable members? Do we have a seconder?
I do, Chair.
Second, Chair.
All right. Thank you very much, honorable members. Any further minutes, Secretariat? I think these were the last set.
Yes, Chair, these were the last sets. Thank you.
Thank you very much. Let me take this opportunity. It's now 5 minutes past 1 o'clock. We are 5 minutes outside. We're outside our time scope. Let me take this opportunity to thank all the members for being part of this meeting, for making your submission. It's highly appreciated on the work of the Portfolio Committee. There are sets of points that we have raised that I think we need to follow up on them and follow up with the Executive Authority in terms of all outstanding matters. So, Secretariat, we do have that register of our resolutions. Let's get back to them. Maybe we can get them, look at them, which ones are red, which ones are amber, which ones are green, including the latest ones of today's discussion. Get them to me, I'll send them to the group so that we know which matters are still outstanding with the department, which matters they've implemented. And if there's others which is a no-no, we raise it also with them. I will appreciate to write a formal letter to them to remind them of all outstanding questions that committee members have raised, including the one of the acting DG, the finalization of the organogram of the DMV, the benefits for beneficiary military veterans. So all of those things, if we can just attend to them. Thank you very much, honorable members. We wish you all the best in your other endeavors. The meeting stands adjourned. Send our regards to your families. I thank you.
Thank you, Chair.
Ba danke, ya leboga.
The decoder.
The veteran of the Revolutionary Army, Commander Hala.
Yeah, we're going to take over now from the ANC.
You can come so long as it's not a coup d'etat.
Take over, it's not going to be a coup d'etat, but to just take over.
Yeah,
Just call all of you to say resign now as we speak over television.
Yeah, let's not fight over benefits.
Yeah. No, sharp, my chief. Sharp.
No, thanks, Commander. All right.